May I request the Honorable Justice, please start.
Thank you, Professor. Before I commence my address, I must congratulate Mr. Nipun Goenka and Professor Ahmad, who have taken great pains to organize this kind of webinars in this difficult time. They intend to keep the students engaged in the field of education and learning. It's a great achievement. Presently, coming back to the topic, one has to understand that the concept of constitutional democracy in its core essentiality embraces two defining features. First, constitutionalism. Second, the democracy. One limits the powers of the government, and the second creates an environment to nurture the democratic process. I would like to say that the ideology of the Constitution and the constitutional democracy encapsulate associated sensibilities which come within the constitutional framework and abdicate or ostracize the dissociated sensibilities which are not permissible or afflict the constitutional values. These two parameters, association of sensibilities and dissociation of sensibilities, are to be kept in view when we talk about constitutional democracy in a democratic body politic. There are many jurists who have spoken about constitutionalism. I must clarify, when you talk about constitutional democracy, you cannot treat constitutionalism as an alien concept. I've already said that constitutional democracy constitutes or defines two fundamental features. Professor Charles Howard McLuhan, he states, I quote, constitutionalism has one essential quality. It is a legal limitation on government. It is the antithesis of arbitrary rule. It's opposite to despotic government, the government of will instead of law, unquote. Thus, the emphasis is there cannot be an arbitrary rule, there has to be a governance by a rule of law. It doesn't conceive of any kind of governance or rule by will. The subjective will has to be abandoned. Every action has to be judged and perceived through objective lens. Objectivity is the primary criteria to control power or to evolve the conception of limitations on power. Simplistically put, the arbitrary exercise of power is an antithesis to the concept of constitutional governance. Any government that goes beyond the limits of its power, it's likely to lose its authority and legitimacy. A government to govern within the parameters of the Constitution has to be a legitimate government and must aspire to sustain the said legitimacy. The constitutional democracy makes out certain devices. It articulates certain principles. It thinks of certain social conditions. Unless they come in, it is extremely difficult to sustain and concretize the concept of constitutional democracy. F.A. Hayek says, and it's quite important what he says, and I quote, constitutionalism means that all power rests on the understanding that it will be exercised according to commonly accepted principles, that the persons on whom power is conferred are selected because it is thought they are most likely to do what is right, not in order that whatever they do should be right. It rests on the last resort on the understanding that power is ultimately not a physical fact but a state of opinion which makes people obey, unquote. Please try to understand. He lays stress on objective formation of decisions and understanding in your role or one's role in a power system. You are conferred power with the understanding that you will be exercising it according to the norms, values, and paradigms, not because of what you feel. Now, in our country, in our framework, Article 14 conceives permissible classification But in the name of permissible classification, there cannot be subtle and shady classification. To elaborate, that to put into the compartment of legitimate classification, when you make maladroit endeavors and try to legitimatize or justify that this comes within the permissible norms of classification as interpreted by the Supreme Court, it is condemned. It must come within that parameter. For that purpose, the court sometimes, not all the time, has used the phraseology egalitarian constitutionalism. You must appreciate why the court has used egalitarian constitutionalism. On certain occasions, you will find a concept comes in, egalitarian spirit of constitutionalism. You see, the constitutional spirit is fundamentally a value-oriented conception. It is prevalent when there is governance by rationality and veneration for the values which are stated or even decipherable by holistic reading of the Constitution. Like I'll give an example which the court has dealt. Power to grant remission, power to commute the sentence. Indubitably, these actions espouse the causes of the liberty. That's one angle. But that does not mean these provisions, while being worked out, or someone exercising this power, cannot become a law unto himself. He has to be guided by the finer concepts of constitutionalism. He must be informed. The word information or the word informed, one has to clearly understand that a decision of this nature has to have reasons. Absence of reason spells of arbitrariness, which is an anathema to the concept of justice. Are you able to hear me, Professor?
Yes, sir. Yes.
Okay. Now, in the concept of constitutional system or constitutionalism, there is averence for absolutism. There cannot be an absolute power, and similarly, there cannot be anarchy. You see, there are certain write-ups, not in the context of constitution, I must clarify, in a different context that a rational anarchist or a rationalist anarchy, though it sounds like a paradox on certain occasions in other fields, not in the field of governance or constitutional governance, I must emphatically clarify. It is conceivable, but in the field of constitutionalism and constitutional governance or constitutional system, as absolutism is not conceivable, similarly, anarchy of any nature is absolutely unthinkable. Now, constitutionalism is a legal principle. It has been regarded as a constitutional principle. Now, I will give an example here. Since early 50s, certain legislations were put in the civil. They were not subject to change in a court of law. Eventually, in 2007, in IR Coelho, the court said, no, it can be challenged because the protection of fundamental rights is sacrosanct. The principle of constitutionalism advocates a check and balance model of separation of powers. It requires a diffusion of powers necessitating different independent centers of decision making. You can't make a legislation and say it can't be challenged. Whatever the reason of the ninth schedule was, the court said it can be challenged. Of course, the court said post 1973. That's another matter. But separation of power has to be recognized. Legislature, judiciary, and executive. They are the three wings of the state. The court has said judges cannot legislate. And similarly, there is no concept known as legislative judgment. Invalidation of law by legislature is one thing, but there cannot be a legislative judgment. There are sometimes allegations that the court is not following strictly the concept and the sense of separation of power. But I would like to say, wherever the court has issued guidelines, those guidelines have been made, established, rested on a fundamental right which has to be cherished. The fundamental right by interpretative process leads to the issuance of guidelines, and that is not legislating. Now, having said about this constitutionalism, I must also focus on various precepts and facets of constitutional democracy. My intention was to state that one cannot understand the perspectives and the vision of constitutional democracy without understanding the basic and the sound principles of constitutionalism. When the Constitution was introduced or put for motion for passing by the Constituent Assembly, Dr. Rajendra Prasad told in the House or told on the floors of the Assembly, Constituent Assembly. It's a very powerful passage. It's still a ledger beam that guides us. He said, and I quote, "It requires men of strong character, men of vision, men who will not sacrifice the interests of the country at large for the sake of smaller groups and areas. We can only hope that the country will throw up such men in abundance." Unquote. I would like to add, this was not the solitary expectation of Dr. Rajendra Prasad. This was the collective expectation of the founding fathers. They were keen that the sanctity of the body polity shall be maintained by the generations to come, and the future shall bring such men on the Mother Earth so that they can live and be guided by constitutional democracy. Now, such men, as all of you know, they come by the process of election. By the process of election, fair and free election is a categorical imperative in a constitutional democracy. Before I go to the subtleties of free and fair election, let me tell you about the secret ballot or the policy behind the secret ballot. Secret ballot is a postulate of constitutional democracy. It expresses the idea of free exercise of franchise. A citizen is free. No one should know how he casts his vote. He is the sovereign there, and he is not afraid or untrammeled, remains untrammeled by any kind of influence when he casts his vote. And that is why the idea of secret ballot. With the passage of time, certain things changed. Litigations traveled to the court pertaining to free and fair election. I'm not saying election disputes. That's permissible, that's different. I'm not saying other litigations are not permitted, but they came with the passage of time. That was not thought of. When criminalization entered into politics, the court observed it's a negation of democracy and subversive of free and fair election. This view of the court, which was stated in 1997, again reiterated in 2002, and they wanted the candidates to fill up certain to give certain information at the time of filing of the nomination papers. In 2013, a matter came to court forming the subject matter of Krishnamurthy versus Shivakumar. In that case, the court talked about the principle of elevated constitutional democracy. I will read few lines from that judgment as I feel it's quite important. They read thus: when criminality enters into the grassroots level as well as at the higher levels, there is a feeling that monstrosity is likely to wither away the multitude and eventually usher in a dreadful fear that would rule supreme, creating an incurable chasm in the spine of the whole citizenry, unquote. Try to see, try to feel, try to realize the anguish and the agony of the court. It emphatically states about the election at the grassroots level up to the parliamentary level. Or I can say from panchayat to parliament, there has to be sacrosanctity in election. A constitution bench in 2014 was addressing the issue of criminalization in politics and how it destroys the very ideal of free and fair election. I've already told the court can't legislate. The court, therefore, evolved certain principles. There is a constitutional trust. There's a concept called constitutional morality. There is a constitutional expectation, and such ideas. These are to be kept in mind by the people who are choosing people to come to power through politics. It expected dedicated discipline and sanguine sanctity from such personalities. It left it at that. Thereafter, you see, the public spirited persons always knock at the door for these purposes. They feel disturbed. In 2018, a matter came almost in similar lines in a different way. The Constitution bench referred to a two-judge bench earlier in a different context. The two-judge bench has said, please mark, I'm not quoting, but please mark the sentence. A corruption as a word is a noun, but when it becomes a verb, it assumes a character of a disease or infection which becomes resistant to antibiotics. And the court referred to various reports, incidents, and eventually said that in a multi-party system, when the party choose the candidates, they must see their antecedents, and if they are involved with heinous offenses, crimes, and charges have been framed, they should not be given tickets to contest in the election. And the legislature would be well advised to make such a law in the interest of democracy. Prior to that, the Election Commission had brought out a principle in a different way that a voter can exercise his negative voting, which is called nota, none of the above. There were many criticisms, but the court upheld it. That yes, as he has a right to vote, he may go there and say, no, I don't find any candidate suitable. And he can exercise that nota. Then with regard to the information pertaining to the antecedents, in 2018, the court had said they must inform the party and there should be newspaper statements plus statements in the television. It's the obligation of the Election Commission to see that the judgment is implemented in full force. Now let's come to another facet of constitutional democracy. In a country which is governed by a written constitution and fundamental rights are protected and equality is kept at the paramount and is placed on a pedestal, one has to conceive, while reading the constitutional language, are they static or dynamic? It is not only dynamic, it is contemporaneously dynamic. And that is why it may be called the contemporary dynamic constitutional democracy. That is how a concept grew, transformative constitution. That you have to read the constitution with a purpose, in consonance with the changing times. One must try to understand the spirit of the constitution and try to avoid any kind of discrimination and maintain the dignity of each individual and the identity of an individual. I have always maintained dignity is divinity. Identity of an individual is the sanctity of his body and mind. You cannot have a dogmatic mindset and proceed to deal with this. Once you have that kind of a mindset, it has a chilling effect on the perspective of the freedom of a citizen. And that is why I always say we must have a progressive outlook, a progressive vision. Regressive perception in 21st century is absolutely impermissible. Let's go slightly away from home. How the Constitutional Court of South Africa has viewed transformative constitution and the conception of constitutional democracy. In 2008, in road accident fund case, the Constitutional Court of South Africa said, I quote, our constitution has often been described as transformative. One of the most important purposes of this transformation is to ensure that by the realization of fundamental socio-economic rights, people disadvantagedly deprived of their social and economic circumstances become more capable of enjoying a life of dignity, freedom, and equality that lies at the heart of our constitutional democracy, unquote. Look at the poignant language, look at the feeling in the passage. And come to just a decade after, our court, while dealing with the rights of the transgenders and the choice of individuals, I'm talking in the context of declaring section 377 of the IPC as ultra vires in part. The court emphasized on three ideas: equality, inclusion, choice, and progressive constitutional democracy. You cannot ignore individual dignity and autonomy. I've already mentioned that constitutional governance is an insegregable part of constitutional democracy. People at the helm of affairs have to exhibit constitutional behavior. You see, the words constitutional behavior have been used by Supreme Court from long. Since long, the court has been expecting the people to behave like this. In NCT Delhi, while talking about the institutions and the people behind that, the court says, I'll quote this passage, nations when institutions of governance fail. The working of a democratic institution is impacted by the statesmanship shown by those in whom the electorate rests the trust to govern in a society such as ours, which is marked by a plurality of cultures, a diversity of tradition, an intricate web of social identity, and a clatter of ideologies, institutional governance, to be robust, must accommodate each one of them. And this unity in diversity, accommodation of plurality, and eventually collaborative federalism, expression of constitutional behavior, improving legitimate constitutional trust, and ultimately maintaining federal balance are the requisite aspects, some of the requisite aspects of constitutional democracy. Way back in 1965, while answering a special reference, the court said, with regard to federal balance, the relationship between the union and the state and other wings, said, I quote, supremacy of the Constitution is fundamental to the existence of a federal state in order to prevent either the legislature of the federal unit or those of the member states from destroying or impairing the delicate balance of power, which satisfies the particular requirements of states which are desirous of union but not prepared to merge their individuality in a unity. Unquote. You must appreciate how subtly the court has struck the balance between the union and the state. Constitutional culture is a part of constitutional democracy. Many people ask, what is this constitutional culture? To live by constitutional norms, values, guidance, devices, and understanding the citizenry responsibility. The responsibility of fostering a constitutional culture always rests on the shoulders of state and the populace. And therefore, Dr. Ambedkar had said, I quote one line, democracy is not merely a form of government, it's essentially respect and reverence towards fellow men, unquote. That respect for fellow men, respect for constitution, respect for dignity are the basic facets of constitutional culture. Here I must tell you, all of us presume or assume that we know this. Many wise things of the past, as Goethe would tell us, have been told 1,000 years back. But the test is they should be rooted in our personal experience. You must experience constitutional culture, and that only you can do when you are a humble being. A constitutional democracy expects confident, powerful, yet humble learners of the constitutional norms and values. In this regard, though it's in a different context altogether, I'm impelled to quote few lines from T.S. Eliot, who says, the only wisdom we can hope to acquire is the wisdom of humility. Humility is endless. Unquote. Likewise, the spirit of constitutional democracy has to be learned, maintained, and sustained with humility by each one of us. Thank you. Thank you very much.
Thank you, sir, for your nice presentation and very depth analysis of the topic constitutional democracy, inherent vision, and perspectives. Now, there are some questions reflecting on the screen. Also, I have some questions. My first question is that how far we have achieved the basic objective of constitutional principle of rule of law in Indian constitutional governance.
In India, a rule of law is the supreme. That is why the courts have pronounced the sovereignty of the Constitution. I will give you 3 examples how rule of law as a principle is established in our system. 1. Transfer of power. In many countries, one might have seen or heard or read, there has been difficulty in transfer of powers. In India, there has been no difficulty at any point of time. Second, no one is ever deprived his rights without following the due procedure of law. Third, you will find we have so many checks and balances. The rule of law eventually prevails, and when the matters come to court, because they are the final arbiters of the Constitution, which propagates the rule of law in a different way. It's not used there, but you can make out what is the rule of law. So I have to go to the extent of saying rule of law has its sanctity and is followed in India like in any mature democracy.
So, the next question is that whether social engineering is being carried out as per the expectations of our founding fathers of Indian Constitution after 73 years of independence.
See, social engineering, one has to understand the concept of social justice. As far as judiciary is concerned, it has delivered plethora of judgments relating to social engineering, social justice, and also carrying out of certain social aspects. Social engineering, some might conceive it's in the field of economics, some may feel in the realm of rights, and some might feel that it should be in the sphere of different kind of equality. See, as far as the executive is concerned, as I understand, there has been various I'm talking about for last 20 years, there has been various schemes at various times to popularize the schemes and to bring in aid the people who are suffering, who are poor, marginalized, and who have not been able to approach various aspects of the modern civilization. There might be some defective measures in the implementation, but the schemes are laudable. While I was the chairman of NALSA, and prior to that, uh, from 2005 to 2009, as the chairman of SALSA, that is State Legal Services Authority, I had seen there are central schemes, state schemes, and one has to see that the executives of all ranks are committed to implement that, and people must be made aware of that. This awareness and implementation, they must go hand in hand. But when I say this, I should not be understood that we have achieved it in perfection. Nothing is perfect, but steps are being taken.
Thank you, sir. The next question is that currently many citizens' inherent rights, including fundamental rights, are getting prime place in the constitutional interpretations, including reading many fundamental rights of citizens. Right to privacy is one of them, but overemphasize on individual rights. How to balance with social interest?
It's an interesting question. The social interest has to be adequately and appositely understood. Constitutionalism emphasizes that efforts are to be made so that the dignity of the individual is maintained. Preamble of the Constitution refers to the dignity of the individual. The fundamental duties contained in Article 51A talks about dignity of the individual. Dignity will not come unless the rights of the individual are protected. Some may say new rights have been created. It's not creation, you see, it's recognition. Each fundamental right is a recognition of a natural right, natural human right. I'll give an example. You talked about Section 377, which has been declared as ultra-virus in part. Is there any reason, any arbitrary reason that those people should be segregated? Because some majority think, no, they should be separate. It's not the constitutional value. It's not the constitutional provision. They have a right. Similarly, many other rights which come, they are in consonance with the Constitution. And that is why I talked about constitutional supremacy or constitutional sovereignty.
So the last question, how far we have achieved the ideals of economic justice enshrined in our preamble? Is it sufficient to provide reservation to economically poor people of the country uh, to achieve economic justice? Just your opinion, sir.
You see, the gentleman who has put the question has introduces two facets. One, can you bring economic justice only by reservation? That's an effort. In Indra Sahani, the court said one has to find out the core and dominant values from the constitution. Whatever they said with regard to the promotion is another matter. Then constitution was amended, that was upheld. That is one mode of bringing them to a particular level in a social strata, which also gives them the economic status. As far as other things are concerned, it's in the realm of executive, how they really bring economic justice. You see, you can't introduce a concept of distributive justice in through a process evolved in a court of law. How the people are to be well equipped in financial matters or economic matters and other kind of connected matters, that has to be best left to the executive because of the policy involved therein.
So thank you very much for a very insightful and very enriched lecture and discussion on the constitutional democracy, inherent vision and perspectives. We are all enriched by your great words. So thank you very much for finding time from busy schedule and agreeing to deliver the talk on this topic. We are really honored. We are really very happy that you found time and deliver your talk. So thank you very much. I also thank